What happens when a criminal complaint is filed years after the alleged incident, with sweeping accusations of rape, conspiracy, and caste-based abuse? Should the courts allow such a case to run its full course, or should they step in early and quash the proceedings? This is not just a question of one man's reputation. It's a question that goes to the heart of criminal jurisprudence. How do we balance the right of a victim to seek justice with the right of an accused to be protected from vexatious or frivolous litigation? Recently, in Pradeep Kumar Kesanwani versus State of UP, the Supreme Court of India dealt with exactly such a dilemma. The case arose out of an Allahabad High Court order refusing to quash a criminal proceeding in the matter involving allegations of rape on the false pretext of marriage. Let us now begin with the facts. The complainant, a student belonging to a scheduled caste, alleged that in the year 2010, she became acquainted with the accused while both were preparing at a coaching institute in Allahabad. According to her, this acquaintance gradually turned into a relationship that soon crossed into coercion. She alleged that the accused forced himself upon her, recorded video clips, and threatened to publicize them if she complained. Over time, she claimed that the accused promised marriage, persuaded her to live with him as his wife, and even subjected her to unnatural sexual acts. In 2011, she said she became pregnant. When she pressed for marriage, the accused allegedly forced her into an abortion and later backed out of his promise. She further alleged that when she and her family approached the accused, they were abused with caste slurs by his relatives. Despite complaints to the police and commissions, no action was taken. Finally, in August 2014, almost 4 years later, she made an application under Section 156(3) CrPC invoking a long list of offences. Sections 323, 504, 376, 452, 377 and 120B of IPC, as well as Section 3 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Now you may already be asking, why such a long delay? Why did the complainant wait for nearly 4 years to approach the court? This very doubt was at the core of Supreme Court's reasoning. But at this stage, remember, the application painted a picture of repeated sexual assault, coercion, betrayal, and caste-based humiliation. The complainant had actually made an application under Section 156(3) CrPC, which would have required the magistrate to direct the police to register and investigate the case. But here, the magistrate chose a different path. Instead of ordering a police investigation, he took cognizance and initiated a magisterial inquiry under Section 202 of CrPC. After completing this inquiry, the magistrate issued the process. He issued summons specifically for the offence of rape under Section 376 IPC. The accused challenged this before the Allahabad High Court, invoking Section 482 of CrPC, which gives the High Court inherent powers to quash criminal proceedings in order to prevent abuse of process or secure the ends of justice. The High Court, however, refused to intervene. At this point, the accused approached the Supreme Court of India, contending that the complaint was wholly unreliable, filed after an unexplained delay, and amounted to harassment through the criminal process. The Supreme Court noted, first and foremost, that the allegations were made in 2014 regarding incidents said to have occurred in 2010 and 2011. This unexplained delay of 4 years was crucial. The court observed that when complaints are filed after such a significant lapse of time and without a satisfactory explanation, they lose their credibility. Second, the court emphasized that on a plain reading of the application itself, the narrative did not inspire confidence. The court made a very important observation. Summoning any person on the basis of a frivolous or vexatious complaint is something very serious. It tarnishes the image of the person against whom false allegations are made. To bring clarity, the Supreme Court then laid down a structured test, a step-by-step framework to be followed by high courts while considering applications for quashing under Section 482 CrPC. Let us carefully understand these 4 steps. Step 1. Is the material relied upon by the accused sound, reasonable, and impeccable in quality? If the material is weak or doubtful, it cannot form the basis of quashing. Step 2. Does the material relied upon by the accused completely rule out the assertions made in the complaint? In other words, Is it strong enough to persuade a reasonable person that the allegations are false? Step 3. Has the prosecution or complainant been able to refute this material? Or is it of such a nature that it simply cannot be refuted? Step 4. Would allowing the trial to proceed despite this material result in abuse of the process of the court and fail to serve the ends of justice? The court made it clear, only when all 4 steps are satisfied, the High Court should exercise its inherent power to quash the proceedings. A common doubt that arises here is, does quashing mean courts are disbelieving victims outright? The answer is no. Courts only quash when the allegations on their face fail to inspire confidence or when the material available unmistakably points to falsehood. Genuine cases are allowed to proceed. Another doubt students often ask is, why not let every matter go to trial? Why stop it at the threshold? Well, a trial is not a harmless exercise. It is time-consuming, costly, and the stigma attached to the victim is permanent, regardless of the eventual acquittal. Preventing such misuse is therefore as much a part of justice as punishing the guilty. To conclude, this case is not just about one man or one complaint. It is about the principle that justice must serve both sides, the victim who seeks redress and the accused who deserves protection from falsehood. By laying down the 4-step test under Section 482 CrPC, the court has given us a structured way to decide when proceedings should be quashed. This saves not just the dignity of the accused, but also the precious time of our overburdened courts. If you found this explanation useful, then subscribe to this channel and join me in exploring more such landmark rulings.